Today we will be looking at the notion of free movement and the European Union internal market. One of the primary objectives of the European Union is to create a fully integrated and homogeneous economic market, where free movement between member states is guaranteed. This has been referred to as the common market, the single market, or the internal market. So what is the scope of the internal market? Article 26 of the Treaty on the Functioning of the European Union, the TFEU, describes the internal market as an area without internal frontiers in which the free movement of goods, persons, services, and capital is possible. Thus, under EU law, the scope of the internal market extends to four main factors of production, namely goods, workers, services, and capital, referred to collectively as the four freedoms. The EU is said to approach the issue of creating the internal market on a sectoral basis. So let's look at each of these four areas, beginning with the area of goods. Article 28 of the TFEU establishes the principle of free movement of goods between member states and calls for the elimination of all barriers to free movement of goods. In particular, the TFEU calls for an end to customs duties and charges or taxes on goods coming from other EU member states. It also calls for an end to quantitative restrictions, i.e. restrictions on the amount of imported goods coming from other member states. And finally, it also requires the suppression of measures having the same or equivalent effect to quantitative restrictions. Now let's look at the area of workers. Article 45 of the TFEU requires that member states abolish restrictions on workers coming from other member states, and in particular, any discrimination based on nationality between workers of the member states as regards employment, remuneration, and other conditions of work and employment. It is important to recall that the notion of free movement in Article 45 only extends to workers and not to people in general. This is because the original EEC treaty was initially primarily concerned with economic matters and thus only provided for free movement of workers. It was only later, as the scope of the European Community evolved and the European Union was established, that free movement began to take in people as opposed to workers, and this extension occurred under the Schengen Accord. To render Article 45 more humane, it has been interpreted by the Court of Justice as including family members, and thus when a worker travels to another member state, members of his family may accompany him. Now let's look at the area of establishment and services. Article 49 of the TFEU defines the right of establishment as the right of any natural or legal person to set up a business in any member state and to pursue commercial activities there. Thus, a company established in one member state has a right to establish a branch or an agency in any other member state and carry out business there. Pursuant to Article 56 of the TFEU, a business also has the right to provide services in other member states without actually establishing a branch or agency in those states. Thus, under Article 56, a bank in the United Kingdom can, for example, ring clients in other member states and provide services for them. For example, to invest money on their behalf, or alternatively, the bank can choose under Article 49 to establish a branch in that member state for the same purpose. Finally, the last freedom is that of capital. The free movement of capital requirement of Article 63 of the TFEU calls for the suppression of exchange controls preventing the transfer of money from one member state to another. Free movement of capital was put in place prior to the establishment of the euro, as otherwise it would have been impossible for the 19 euro member states to have a common currency. Now let's take a look at the principles on which the single market, or internal market, is constructed. The success of the internal market was undermined by the fact that member states remained free to restrict free movement where the restriction was justified on grounds of public policy or was not directly discriminatory in effect. At the time of the establishment of the EEC, or the later EU, each member state had in place different rules governing the manufacture of goods and the exercise of professional activities. For example, imagine the 28 member states have different rules in place regarding the period of time one has to study in order to become a nurse. In the absence of EU legislation harmonising nurses' qualifications, nurses wishing to provide their services on a pan-European basis would have to respect 28 different sets of member state rules. As the rules could either be claimed to come under the heading of public policy or alternatively to be non-discriminatory in effect, as they would apply equally to everyone. In this way, the rules could be justified. However, as a result of rules of this kind, service providers and consumers were denied the benefit of a real single market, as free movement was restricted by what we will call secondary member state legislation. Initially, when trying to adopt directives coordinating the different member state legislation governing the free movement of goods, workers, services and capital, the Union authorities sought to establish a harmonised European-wide set of rules. These rules would be applicable in all member states. However, this proved too complicated to achieve, and as a result, progress as regards the development of the single market was very slow. Indeed, by the 1980s, much work remained to be done. Consequently, the Commission suggested, on the basis of European Court of Justice case law, namely the Cassis de Dijon decision, that instead of relying on harmonisation, the Union authorities should apply the principle of mutual recognition as a means of coordinating member state legislation. Mutual recognition is a mechanism whereby states mutually recognise the standards and rules in place in each other's state and agree on the basis of reciprocity to permit goods, services and people to circulate freely between them. Under such a system, it would not be necessary to harmonise member state rules, but rather to establish a process in which 28 different sets of rules are applicable and recognised mutually. Such a system can lead to competition between the different member state regulatory systems, and some European Union member states opposed its application, as they felt it would encourage a phenomenon referred to as negative regulatory competition, also called a race to the bottom or the Delaware effect. Negative competition occurs when member state regulatory authorities, in order to become an attractive location for business, begin to compete with each other as regards the content of their regulatory systems. For example, they can do this by reducing the prudential rules they have in place regulating business. This will lead to a reduction in compliance costs for business located in their state, and thus make it a more attractive business location. The member state then benefits from increased employment and increased tax revenues. To compete with them, other member states will in turn lower their prudential standards, leading the system to spiral into a process of negative competition. As a result of these worries, the Union authorities developed a new approach as a system to create the single market. Under the new approach, the Union authorities rely on a mixture of harmonisation and mutual recognition. Thus, when seeking to introduce free movement into an area, for example, nurses, the Union will adopt an EU directive harmonising these rules that it considers to be vital both for the sector and for EU citizens, for example, the protection of consumers. Once the rules applicable to these areas are harmonized by directive, mutual recognition then remains the operative principle as regards free movement in this area. The Union also established the principle of home member state control to operate alongside the principle of mutual recognition and limited harmonization. Under this system, it is the home member state in which the business is established and not the host member state that regulates the business in question. We hope you enjoyed this introduction to the EU internal market.